If you're dealing with debt and you've received a default notice, it's essential to act quickly to avoid the possibility of court action. In this video, we'll discuss how to respond to a default notice, the importance of open communication with debt collectors, and the steps to follow to prevent the issue from escalating to court. Remember, time is of the essence, so let's get straight into it. Responding to a default notice. When you receive a default notice, it's crucial to address it as soon as possible. This notice means that your account's on the verge of being cancelled or defaulted, which will have significant consequences on your credit score. You usually have about 2 weeks to get your payments in order and amend your situation. If your account gets defaulted, it will negatively impact your credit score and stay on your credit file for 6 years. This makes it all the more important to act quickly. On this note, though, if you still don't think the debt's yours, it's really important to communicate so that you can clear the debt from your name. Communicating with debt collectors. It's essential to be transparent and communicative with debt collection agencies to avoid being taken to court. Reach out to your creditor and explain your financial situation, showing them that you're doing everything you can to pay off your debt. If you lack the money to pay off your debts properly, you can contact an independent charity like Step Change for help. They can assess your situation and help you set up a payment plan for your creditor, potentially preventing further legal action. Replying to the letter of claim. When you receive a letter of claim from your creditor or a debt collection agency, you need to reply within 30 days using the included reply form. You have the option to agree that you owe all, some, or none of the money. You can also request more information if you're unsure about the debt. Remember, it's their job to prove that you owe the debt. Make sure to send the completed reply form and statement of means form to your creditor. The statement of means form is similar to your personal budget. It allows you to provide details about your circumstances, income, and expenditure. If you don't reply within 30 days, the court may add extra interest to your debt, making the situation even worse. So what happens if you can't reach an agreement? Well, if you can't come to an agreement with your creditor after replying to the letter of claim, then they should give you at least 14 days notice before starting a court claim. Keep in mind that the creditor can't start a court claim within 30 days of receiving the completed reply form or 30 days of providing you with the requested documents. This gives you some time to explore other options or seek professional help to resolve the situation. Receiving a claim form. So if you receive a claim form, it's vital to fill it out and return it straight away. This document serves to inform you that court action is being considered against you. The claim form must include comprehensive and detailed information about your debt, such as the amount of debt you owe, the payments you missed, and the payment plan you agreed upon. If you believe that you're being wrongly targeted, then you can seek advice from an independent charity that can guide you on what to do next. The county court judgment, you might know it as a CCJ. Now, if you can't reach an agreement with your creditor after all these steps, then they may decide to pursue a county court judgment against you. This legal action could further complicate your financial situation and make it even harder to recover. You have 3 options when facing a CCJ. Number 1, accept the CCJ. If the debt's valid and you can afford to pay, consider accepting the CCJ and filling out the admission form. Keep in mind that your creditor will be in control of the repayment terms. Number 2, suggest changes in the CCJ terms. If you can't afford the proposed terms or can't pay the debt at all, apply to change the terms using court form N244 or N245. You'll need to provide evidence of your financial situation like income, expenditure, or medical records. Number 3, reject the CCJ. Now, this is rare and requires a significant reason like the creditor not following guidelines or violating Financial Conduct Authority regulations. However, rejecting the CCJ doesn't write off your debt. Your creditor can still attempt to recover it. Dealing with a default notice and the threat of court action can be incredibly stressful, but it's important to remember that there are steps that you can take to resolve the issue and prevent further escalation. By responding promptly, communicating openly with debt collectors, seeking professional help when needed, and staying informed about your rights, you can successfully navigate this challenging situation and protect your financial well-being. Remember, the sooner you take action, the better your chances of finding a positive resolution. If the debt does belong to you and you're struggling to work out how to pay it, you may want to look into debt solutions. Some of them will lower your monthly repayments, and others can even write off some of the debt. It all depends on what you qualify for and your unique situation. Below the video, I've linked to a form and it'll run through a handful of multiple choice questions. At the end of the video, it'll connect you to a company that I've partnered with, and they've got all the information that you need about debt solutions that are available to you. Best of luck, and I hope this video has helped you to react on time and avoid court. Thanks for watching, and let me know how you get on.